underlying transcript if they're looking at the evidence that was before the body that made the actual determination, whether it be township or whether, in this case, be city council. If you read those cases, you read them carefully, you can see they have the underlying transcripts of those proceedings. Not in all of them, I would assume not in all of them, but in a good majority of them. Because there's no way they could be reaching these findings of what the board did and didn't do. If they didn't have
is the Chartiers or whatever, is that case, do you think, the best one, and do you have a copy of it for me?
I have my writing on it. I don't know that. I didn't make a copy.
Okay, no problem. I mean, you. Yeah, I know this is. Okay.
To my mind, I'm sorry. May I?
Yeah.
The very invitation by Mr. Stevens that if the city wants to contest things that were said in these transcripts, is that we can call witnesses, suggests that it matters that we accept what's said in those transcripts for the truth. Because if that's not the case, then why do I need to call anyone to testify adversely to what was said? Or why do I need to cross-examine anyone who made statements reflected in those transcripts? If all that matters is what was said, then I think the invitation to cross-examine anyone or call adverse witnesses is superfluous, because there's in fact nothing to contest, because we're not contesting the truth. So I think that very invitation by Mr. Stevens, I think gets to the core of this. We are concerned with what was said in there for its truth. We are concerned with offering the statements made by planning commission members and city council members for their truth. And because that's the case, I don't think it can come.
Okay, this may be jumping ahead a little bit, but I think it'll help us on this question, which is, what if Mr. Stevens asked us to subpoena the entire council and all the members of the planning commission? I mean, is it anyone on your side of the table saying you can't do that for a reason? In other words, would that be equally irrelevant in your minds, or is it actually getting closer to relevancy if that's the alternative? Because you're saying he can't use the transcript. This question still becomes, okay, if he can't use the transcript, he can't use the video, should he be subpoenaing? Because in theory, one of the arguments could be they have nothing relevant to the proceeding before you. Right? Because we're past that. That's a legitimate argument. And I'm just curious, because we'll get on to the subpoena issue later, but I think what the arguments that both sides are preventing makes us almost ask that question now, right?
I think if you called members of the city council and the planning commission here to testify under oath, that would solve the problem that I sort of raised, where you have the transcripts offered for the statements that were made to show the effect on the listener. And therefore, you don't need those statements offered for their truth. But then you have the council members here who are testifying under oath and who are making statements that are offered for the truth. So it would kind of close that problem or solve that problem. However, I obviously have the underlying objection that none of this is relevant.
Gotcha.
Because what we're concerned about is the text of the zoning amendment and its operative effect on the city's zoning scheme.
And I guess the reason I'm leading people down that path is it seems like the only thing we can't correct by doing something differently is whether it's relevant or not legally, right? Because we can fix them by playing the tape so that we're not reading it. Then we say, well, it's still hearsay. Okay, we could bring people in under oath. We still get down to that baseline determination of, is it even relevant to be doing any of this, or is it an exercise in futility because we shouldn't be even thinking about it? And Mr. Stevens is saying, under Chartiers and the other cases, it's absolutely relevant, and your argument is it's not relevant, right?
No, it's neither one of those. There are standards that the courts have developed to evaluate whether or not a zoning ordinance is defective, and they're pretty well known. Whether it's a map or a text change is one of the first considerations. If it's a map change or if it's a text change, what does it control? What areas are in play? Are they, if it's a spot zoning challenge, which I believe we have here, is the area that's in question, is it indistinguishable from surrounding properties? I'm not going to go down the list. You know the list as well as I do. And then there are other considerations. The courts talk about the comprehensive plan. They talk about whether it's arbitrary, whether it's unreasonable. And those are matters that are explored in hearings through testimony. Because someone may come in, a planner, with the opinion that it is unreasonable, but upon cross-examination, it may turn out that that opinion is really not well-founded. That's how it's supposed to work. What they're asking you to do is to jettison all that, do a document dump, and then rely on that for the truth of the matters asserted in the document dump. I'm not saying that what Mr. Stevens is incorrect and that you can't consider whether it's irrational, whether it's arbitrary. You need to do that. And if he wants to put on evidence of that, he should be doing that. But to go back and explore the transcripts that happened in front of the hearing and dumping them in toto, I don't think it's correct. I don't think it's proper.
What was the, if I may ask, what was the case that Mr. Stevens had cited? Was it Streck? Is that? Okay.
Chartiers, 677 Atlantic 2nd, 1274 is the one he cited for this
And may I
issue.
just respond to the comments about it being a document dump? It by no means is a document dump, because it's actually meant to shorten these proceedings, because there are witnesses who got up in front of city council and gave their statements, and the idea is, are we going to really say anything different in here? No. And we can rely upon those transcripts, because that really is the best evidence here, because that was what was considered before the court in their passage of the act. Where this will be shortened even further is we'll rely upon these various transcripts, cite to them in the findings of fact and conclusions of law, and then in this board's final determination can adopt whatever they feel is appropriate. So again, that will thin the documents that you have to ultimately review, because there will be specific citations to the record that support what counsel is advocating on behalf of their respective clients. So I'm actually suggesting this to streamline these proceedings, and at the end of the day, this board, and it's in the MDC, has very, and in the supporting case has very, very wide discretion in its determination of what is relevant, and can make then the determination, you submit the evidence, admit it, and then make a determination as to its weight. And to the extent we call live witnesses and hear from them to clarify various issues, and there are many issues in this challenge, including procedural issues where we do need the live witnesses beyond the bare transcript to clarify things and to bring them in and talk to them. But the core of this, to have the underlying transcript that was before City Council, I think is intrinsic to your duty as the zoning hearing board to review that legislative history, and then to take any additional evidence that is deemed appropriate to clarify the issues that we're raising on appeal and that they're responding to.
Can I just ask for a copy of the case? Can I see what you have there, the Chartiers case? I mean, if we're going to argue about that, can I at least be entitled to look at it?
Sure. I mean, it's got my notes on it.
I'd just like to note the case for the record. This is Streck versus Lower Macungie Township Board of Commissioners. It's a Commonwealth Court case from 2012, 58 Atlantic 3rd, 868. A court may not rescind a properly enacted zoning ordinance that applies to the general public. To avoid an ordinance on substantive grounds, the challenger must show that the ordinance is arbitrary or unreasonably discriminatory or without substantial relation to the public health, safety, morals, or general welfare. Further, the court will not inquire into the motives of a municipal legislative body in making zoning changes.
Okay.
And that's not the sole issue. It's not just the motives that we're looking at. We're looking at the factual determination that was before the board, whether or not they did their due diligence, whether or not they properly looked at the comprehensive plan. We're looking at the confusion amongst city planning as well as the applicant in the actual language and the ambiguity of the language that's borne out in the underlying transcripts, and we'll bring other witnesses in to further clarify those issues. But to start fresh without having that, what what preceded you, and to try to start fresh and recreate essentially 4 evenings of hearings, 10, 15 hours of proceedings, I think is counterproductive in that you'll have what went before you, and then we can recall a few individual witnesses and clarify.
You have a copy of Strack?
No, I was, these are part of my examination notes for tonight. I don't
Oh,
have a separate copy,
okay.
I'm sorry. It was convenient enough that the quote appeared in what I had.
All right.
I mean, to give, before, I don't know if you're going to make a determination, but I think to give this more context and to better amplify the need for both the transcripts as well as the exhibits that were before the board, and if I can outline the framework of what our challenge is to this zoning amendment, may elucidate the value of having the transcripts.
I don't think we're there yet.
Okay.
That's just my
Yeah,
personal
well,
opinion. I just don't think, yeah.
Well, I guess I would say, does the board want to discuss this? And
Yes.
if you decide that you need to take Mr. Stevens up on his offer, you will do so.
Correct.
Okay, let's do that.
We're going to go off the record in the executive session for a few moments.